Liability under the rule in Rylands and Fletcher by Camilla Chadder. The case of Rylands and Fletcher, 1868, established a new tort, which was also a subspecies of the tort of private nuisance. It provided liability for defendants who accumulated something on their land which was likely to do mischief, and this in fact escapes and does mischief and causes damage of foreseeable type, all in the course of a non-natural use of land. Thus, the tort of Rylands and Fletcher can be separated into 5 components. Accumulation, something likely to do mischief, which in fact escapes and causes damage of foreseeable kind during the course of non-natural use of land. So the first component of Rylands is accumulation. This is the idea that something has to be brought onto the land. It's artificial to the land and not naturally occurring. For example, in Giles and Walker, 1890, it was held that there could be no accumulation owing to the failure to cut thistles because they were naturally growing on the defendant's land. However, in Rylands, the water in the reservoir that was artificially brought there, thus accumulation could be established. In addition, in LMS International and styrene packaging, the flammable products were put there artificially on the land, i.e. they did contribute to accumulation of an artificial dangerous substance on the land. The next requirement is that the accumulated substance has to be likely to do mischief if it escapes. This does not mean that the item itself has to be intrinsically dangerous. So in Rylands, it was water which escaped. This is not intrinsically dangerous, but the quantity that was there was a dangerous amount. In addition, we can compare this to Transco, where the water which escaped, because it was limited in quantity to the amount that was required for the residents' water supply, this could not be said to do mischief if it escapes. And the key problem with this part of the requirement is that it's not so clear-cut, and so factors which affect this requirement also affect the non-natural use of land requirement. So in Rickards and Lothian 1913, Lord Moulton treated explicitly increased danger to others as an element of non-natural use. It's hard to disentangle the requirement. The next requirement is this potentially dangerous substance escapes. In Rylands, the risk materialized when the water flooded off the defendant's property into the plaintiff's mine. This is a requirement of movement. So we can understand this by looking at the case of Reed and Lyons, 1947. Here an explosion in a munitions factory did not involve an escape because it stayed in the defendant's factory, and so no action in Rylands was possible. The type of damage which is recoverable under this tort is limited to damage to land or property on the land, and this was clarified in Cambridge Water and Eastern Counties Leather 1994. And in Transco 2003, it was suggested this is because it is very closely related to the tort of nuisance. So if there was any personal injury, that would have to be brought in as a negligence claim. Cambridge Water went on to specify that the courts must question whether the given escape, for which there is strict liability, would this resultant damage have been reasonably foreseeable. This ties into the principles of remoteness, which is so key in the area of tort. The final requirement is that this all must take place within a non-natural use of land. So what does this mean? Well, the current definition is given by Transco and Stockport MPC 2003, which suggests that a non-natural use must involve an exceptionally dangerous or mischievous thing in extraordinary or unusual circumstances. This is subjective and it's all dependent on the facts. And time will also be a key factor in it. So for example, in Musgrove and Pandalis, a motor car in a garage was deemed to be non-natural use of land because of the era in which science was then. However, now this would not be the case. And for example, in Rickards and Lothian, a sink being left to overflow, that was deemed a natural use of land. So you can see from the cases in the table that it's very much dependent on the facts of the case. There are five key defenses in relation to the rule in Rylands and Fletcher. The first is consent of the claimant or common benefit. The second is act of strangers or third parties. Then you have acts of God, then statutory authority, and finally the default of the claimant themselves. The common benefit of the potentially dangerous and mischievous activity and consent implied or expressed will be taken into account. So, for example, in Carstairs and Taylor, 1971, rainwater which was collected and stored, which a rat gnawed through the container causing the flooding, a claim could not be found under Rylands and Fletcher, and this was because the rainwater was kept there for the common benefit of all inhabitants. Where the tort is caused by an act of an unknown third party over whom the defendant has no control, he will be liable in Rylands. This defence operated in Perry and Kendrick's 1956, where the child trespassed threw a lighted match onto a petrol tank, causing an explosion. Furthermore, in Northern Western Utilities Limited and London Guaranteed Co. 1939, the House of Lords said an exception to the rule in Rylands would be where the damage was caused by the fault of a third party, independent and conscious act of a third party. An act of God defense operates in exceptional events, for example, an earthquake. It was successfully utilized in Nicholas and Marsland 1976, where heavy rainstorm qualified for this defense. It's probably not applicable today because we have weather forecasts, etc., but it was also used in 1864 in Tennant and Earl of Glasgow, where there was exceptional rainfall that had caused some kind of foreseeable damage. A defense of statutory authority exists when the defendant was doing the activity by a given power of statute. So in Dunn and Birmingham Canal Co., what happened was the defendant Canal Company, because of its statutory authority, was held not to be liable for allowing the escape of water from its canal. And finally, there are cases where the claimant themselves is to be held liable. Because, for example, in Poynting and Noakes, 1894, this is where the horse got poisoned by eating a dangerous, I think it was a yew tree of the neighbour. And it was held that it's the claimant's own fault for not controlling the horse that such damage took place. Thank you for watching, and you can find more videos and information on CAMILACHADDER.com.